Yeah, thanks for joining. This is the first webinar of a series of webinars to come. We're going to be doing these quite frequently about a range of different topics, talking about the property market, changes, updates, and also new launches that CityRise are bringing to the market. But what better way to kick things off than to talk about the hot topic of the Renters' Rights Bill. So I'm here with Ross, who is head of our lettings team. I'm Reuben, co-founder and director of CityRise. So yeah, today I'm going to kind of let Ross just talk about what the Renters' Rights Bill means for you as landlords. And I've got a load of questions here, which some of you have already asked. There is a live chat as well if you want to pop any questions in there. So I'll kind of let Ross talk about the Renters' Rights Bill, what it means for you, and I will be butting in, asking him some questions along the way. And if there's anything that you're still unsure of by the end, then hopefully I can go over some more questions. So yeah, over to you, Ross. Do you want to kind of explain what we're going to be covering today?
Yeah, thanks, Reuben. So today obviously the hot topic in the property industry, especially on the letting side, is the Renters' Rights Act, which got passed into law in October. So it's all still fresh in people's minds. It's a difficult topic for a lot of people to deal with because there's a lot of misinformation out there, a lot of uncertainty. So what we're going to hopefully bring today is a bit of clarity to the process and how this is going to be rolled out in what the government have called their roadmap of implementation. So we're going to go through a couple of the main talking points and concerns that people have had over the last few months. This has been a long time coming. It's about 30 months since it was first introduced by the previous government as part of their agenda. Unfortunately, we got all the way to the final hurdle and they couldn't get it passed through to become law before the general election. So after the general election, it was taken on by the new government and they had to restart the whole process again. So it was previously known as the Renters Reform Bill. When the new government came in, Labour took over, they rebranded it as the Renters' Rights Bill, but it was basically exactly the same piece of legislation. But then we had to, like I say, start the whole process again, going through the House of Commons, the House of Lords, going through ping pong where they go backwards and forwards and make any amendments and they argue over the different points within the bill before it gets royal assent and then passed into law. And like I said, that happened in October of this year. So just to give a bit of background to the main talking points that I've been hearing over the last 2.5 years. Most things that people are worried about is the abolishment of Section 21s, which is a common thing people talk about, the end of fixed term tenancies, the fact that the property market will no longer have minimum 6-month, 12-month contracts. It will now be a rolling contract from day one, so a 1-month contract, and then automatically a periodic tenancy after that. The issue with pets, that's a real hot topic, that landlords are concerned that that tenants can have whatever pet they would like in a property without any jurisdiction from the landlord or the agent. The fact that landlords may find it more difficult to get possession of their property because of the abolishment of the Section 21 notices and the fact that they now have to rely on Section 8 notices. So we'll touch on that in a bit more detail. And then also the new landlord PRS database, so the private rented sector database that every landlord will have to be a member of. So most agents are a member of the Ombudsman or the PRS, somewhere where a tenant can report an agent to if they're unhappy with the service they're providing, but it's never been a requirement before for landlords to have the same governing body hanging over them. I think that's quite a good thing for me as an agent. It means that we're not the only person accountable for the actions of the landlord. But it just means as well that you, as a landlord, need to make sure you are following the correct procedures, you are following the law, and you don't give the tenant any reason to report you to a governing body because they can now take action against yourself. And it is the council who have now been appointed as the adjudicator in this situation. So the council will obviously look to make money where they can. So we are expecting quite a lot of these ambulance chasing solicitors to pop up, where no win, no fee, where tenants can report to them any concerns they have, and then you are accountable as a landlord now, which is good news for the industry because there's a lot of rogue landlords out there, but it just means that if you're looking to self-manage, which I wouldn't recommend, but then I am biased, just make sure you do read up on this. Again, I'm going to give you a whistle-stop tour in the next half an hour about the Renters' Rights Act. But as this is rolled out over the next 5 years, and that's the plan they have, you need to make sure you hit all the milestones and make sure you do things properly as you need to do.
And Ross, just before we kind of touch into kind of a deep dive into the main points, do you want to kind of tell our landlords and everyone listening what we're going to be doing as a company, to kind of action points that we're going to be taking immediately?
So there's a number of things we are going to do that's possibly not necessary, but we feel that it's the best way to protect our clients. So with the new legislation also abolishing this section, the fixed term tenancies, and every tenancy becoming from the 1st of May next year, rather than an AST, an assured short-hold tenancy, it's going to become an APT, an assured periodic tenancy. There's various wording that you have to have within a tenancy agreement. There's leaflets that you have to issue out to tenants. These will have to be done by certain dates, so we'll be doing those as standard practice. But what we've also decided to do is just to reissue all our tenants with brand new tenancy agreements, so that all the new wording is covered within the paperwork that they have, and we're not opening ourselves up for any issues down the line where tenants can try and hold us accountable. We're also looking to allow some extra security for our clients. We're about to launch a new service offering called Management Protect, which will just give landlords more security. It's similar to a rent protection policy and a professional guarantor, so it allows landlords to have that additional security that they would normally get with a tenant providing a guarantor. This means the landlord can actually provide themselves with a guarantor, which is something which is not normal in the industry. It's been out for a while, but it's not really well known. It'll give the landlord a lot of extra benefits, such as 24-month rent cover. So if your tenant doesn't pay your rent, you can claim that money back up to 24 months worth of rent. The product will then, or the company that run it, will also then take the tenant to court, issuing notices to the tenant. Covers all your legal fees up to £50,000. And the benefit that I found as well, it also gives you the equivalent of 10 weeks cover for any damages at the end of the tenancy. So especially with the issues around pets and tenants having the ability to have a pet and landlords not being able to unreasonably deny a tenant's right to have a pet, there is concern about the amount of damage that could be caused. So a standard cash deposit is capped at 5 weeks rent. There are products out there where you get additional 1 week's rent. So our current product gives everyone an extra week's rent as standard. So 6 weeks cover. There are some out there that cover 8 weeks cover with rent guarantee policies. Ours will cover 10 weeks, but that's purely just for damage, because you also get the 24 months cover for rent arrears. So if you had £1,000 rent and you deposit, for say it was £1,250, and they didn't pay the last month's rent, you can claim back that £1,000 in lost rent. But then rather than just having £250 for damage, if they cause a lot of damage in the property, you've got an additional amount of money there to claim back, so you're not out of pocket. So we're really trying to protect the landlord as much as we possibly can to make sure their investment is secure for the future.
Sure. I think, for a lot of landlords I speak to, clients or just general people from different walks of life, and for myself being a landlord as well, I think the thing that seems to be very confusing, that I was confused about, and luckily I've got you to tell me what I need to do and when I need to do it, but is the timeline of everything that's being implemented, because there's a lot of different bits coming in at different dates, which certainly confused me. So I think maybe if we could just explain that to everyone, maybe a bit of a timeline of the key things coming in and when they need to be done by, and then hopefully I can fire some questions that come in on each topic as we go through them. Yeah,
of course we can. I think it's probably worth pointing out as well that this is just the next evolution of the rental industry and for investors. I've been doing this nearly 25 years now, and I've seen a number of changes throughout my career. And if you think back, there's been huge milestones of that period. So 30 years ago, there was no requirement for gas certificates. 20 years ago, there was no requirement for deposit registration and caps on deposit amounts. Even 10 years ago, there was no requirement for electrical certification for rental properties. These are all common practice now, and everybody at the time got really heads up about the changes. Even the tenant fee act and tenant fee ban, when that came in, that was a huge change. Now it's just normal, and everyone's got over it, that initial surge of uncertainty. And I think that's what happened with this, is once it's bedded down, everyone becomes familiar with it. I mean, it's been this way in Scotland for a number of years, so it's not new to the UK, it's just new to England. But we'll go through the timeline. Apologies if I end up reading this more, but I want to make sure I get everything right as we go through. But like I said, I'm sure Reuben will pick me up on certain bits and ask questions as we go through. So like I said, back in October, 27th of October is when the bill got royal assent and became an act. That's when it becomes law. And this just means it enabled the government to then create sporting regulations around the bill. On the 13th of November, the government then released the implementation roadmap, which just explains the fact that this is going to be rolled out over a 3-phase setup. The initial rollout will happen quite quickly, and then there's quite a long delay until the phase 2 and phase 3, so we'll go through those. So phase 1, when the first part of the act becomes active on the 27th of December. That may sound like a strange date, but it's just 2 months after the bill became an act and passed into law. This is when the powers are rolled out to the local government, to local councils, to enforce the act. So it's really important that, be careful what I say here, you no longer treat the council as an advisory service. They are now the enforcers. And obviously councils will try and make money where they can, and there are severe fines for not doing things properly. So just bear that in mind. So the local council will have new investigatory powers, so they can enter your property on 24 hours notice without a warrant. They can search the property, they can take away documents as evidence and use them against you. So they can just knock on your tenant's door and say, we'd like to come round and have a look at the property tomorrow. You can't stop them. In January, the government's going to be issuing the wording for new tenancy agreements. So all tenancy agreements are going to have specific wording within them, which means that if you don't have that wording, your tenancy is invalid. And again, you can get fined for not having that in place.
I think just on that point as well, there's going to be a lot of tenants out there that are going to know this information and be looking to scrutinise landlords where they can and find holes. So I think whether you're using CityRise, you're doing it yourself, or you're using a different letting agent, having someone in your team, ideally a letting agent that knows what they're doing, is going to be really important from that side of things.
It is. I mean, just education is key in making sure you stay ahead of the game, because ignorance is not an excuse, and you end up with quite hefty fines. I mean, when we say fines, we're talking that currently the maximum fine, I think, is £5,000 for individual occurrences. If that's going up to £7,000 for repeat offences. And when I say repeat offences, if you're a landlord with 20 properties, each offence is counted, even if it's the same offence, but over 20 different properties. So you make one mistake in your tenancy agreement, use that same tenancy agreement for each property, you're then at 20 offences, counts as a repeat offender, and it's up to £30,000 per offence. So please do take heed of that. Just as Reuben said, with the tenants being more knowledgeable, that's one thing the government are looking to do. So in March, the government are going to be issuing a leaflet of guidance notes for tenants. So we will be issuing that on behalf of our clients. If you are self-managing yourself, you need to get hold of that, and you need to make sure you issue it to your tenants and document the fact you have given it to them.
Just going to nip in there as well and just say this whole session is being recorded. If you can't see us, don't worry, we are still recording, so you can watch this back at any time. We will be sending it out to you. Just thought I'd mention that before we carry on.
Not a problem. And then in April 2026, the government starts their communications campaign. So they're going to start, I would imagine, with TV adverts, radio adverts, and also social media posts going out about these changes and what the tenants need to look out for. And because, as I say, as landlords, you are ultimately responsible. And that's another point to make, actually. Just so if you are with another agency, not that there's any reason to be, come see CityRise, you cannot blame your agent if something is not correct in your tenancy agreement. The tenancy agreement is between you and your tenant. The agent just works for you as your agent. So any mistakes that they make, you are responsible for. So just be very careful again. The main date that people talk about is the 1st of May. That's the main, when the main elements start to be enforced with implementation and key changes. So this is when the end of the fixed terms happened. So as of the 1st of May, every single AST in the country, whether it be fixed term or periodic, will become a periodic tenancy. So if you sign a 12-month contract with your tenant on the 28th of April, and it's a 12-month contract, on the 1st of May, it becomes a rolling contract from that date. So one thing I would say for landlords, if you are looking to rent your property currently, a lot of landlords would insist on a 12-month minimum term. If you get a tenant now, from now on, who only wants 6 months, don't say no. Just take them up on it, because it doesn't make any difference at all. You do a 12-month contract today, 1st of May, it becomes a rolling contract. So it's no different from a 6-month contract. So just bear that in mind. Not only this time of year, just good to get a tenant in quickly. The new tenancy agreement wording must be used from the 1st of May. The end of the Section 21s and Section 8s of notices will happen. Any notices served before the 1st of May will remain valid for their normal expiry on the 1st of August. So, on their expiry or the 1st of August. So normally you get a 6-month shelf life for notices to be able to go to court to get possession. So you will still be able to rely on those if you've issued them before the 1st of May, as long as you went to court before the 1st of August or before the end of the 6 months.
Yeah, I think that's probably, out of all the questions we've had in, that's one of the main ones that seems to be recurring from a lot of people. You know, people worried about how do they regain possession of their property should they need to. So I don't know if you want to explain kind of certain circumstances where they will be able to get in.
Yeah, I think that the essence of it is about understanding what are the differences between a Section 21 and a Section 8. A Section 21 is what they call a no-fault eviction. So a landlord doesn't have to give a tenant a reason why they're asking them to leave. As long as they're outside a fixed-term tenancy, you could serve a Section 21, and it's a mandatory grounds for possession, so a judge can't say, no, you can't have possession of your property. And landlords would use this regardless of the circumstances. So you've got a bad tenant, unsociable tenant, antisocial tenant, a tenant in rent arrears, a tenant who's persistently in rent arrears for small amounts. You don't have to go through all the rigmarole of choosing the reason why you're getting possession from them. It's an automatic grant of possession. The judge will not say no. With a Section 8, you have to give a reason, and you have to get it correct. And to do a Section 8 yourself, if you're not knowledgeable and skilled in that, is difficult. And again, if you're a self-managing landlord, I would be telling you to go to see a solicitor. And yes, it's going to cost you hundreds of pounds to do that. Obviously, we do it for our clients. I've been doing this a long time. I have the help of a legal helpline provided by Property Mark if I need it. But the grounds under which you get possession, you have to be very careful of which ones you use. I personally don't see a difference. There's no real difference between how you get possession. You serve a notice, and if your tenant doesn't adhere to that notice, you then go to court. I've done this a long time, and I've been to court 4 times through the various companies I've worked for, various tenancies I've looked after, which is thousands and thousands of tenancies. It doesn't happen as much as you would think, but it's all about making sure you do your due diligence at the start of the tenancy, throughout the tenancy, and also at the end of the tenancy, making sure you get your documentation correct. So please do use a qualified, regulated agent to do your legal paperwork for you.
Ross, just a quick question, just coming on the feed from someone kind of worried about void periods when moving into kind of the periodic tenancies. How's it going to kind of impact kind of the reletting cycle. As far as I'm aware, it's not going to be any different because they still have to give notice. But
they do, but it's actually more positive. That's more positive news for landlords, because a tenant's going to be required to give more notice. So currently they have to give 1 month's notice from the next rent due date to end the tenancy and move out. They're now going to be required to give 2 months' notice to end the tenancy. So you're getting double the amount of marketing time before the property becomes empty, before you hit a void. So normal circumstances, if the tenant gave notice the day before their rent was due, you process the termination, you'd have 4 weeks to find a new tenant before your property being void and you're without a rental income. You'll now have double that amount of time. So you should be marketing the property, straight away, 8 weeks before it becomes empty, finding a tenant to be lined up to move in as soon as the next tenant moves out. Allow a slight gap in between to make sure you get this property ready for the new tenants. But otherwise, I see it as a positive. Landlords, again, if you want to give notice to your tenant, the notice does increase. So it'd be a standard a 3-month notice period as opposed to normal 2 months notice as at the moment.
Perfect.
And then the last thing that's happening on the 1st of May, you've got the changes for rent increases, the rules for that, advanced rent requirements, the new legislation for pets, rent bidding and discrimination. So just to kind of touch on those points really, for rent increases. So again, this has been a bit of a hot topic, people asking, well, how often can I increase the rent? When can I do this? What are the effects of the new laws? It doesn't really change that much different from how it is now. So you've got a Section 13 notice, which you have to use now to legally increase the rent. That'd be the same. You still have to serve a Section 13 notice to increase the rent. There are going to be changes with regards to taking rent in advance. That will be a no-no going forward. It's be banned, so you can no longer take rent in advance from tenants. So if you do deal with things like international students, just be wary of this, because you can't take rent in advance. You can only take a maximum of 1 month, that's it. After the tenancy has started, you can take rent in advance, but you can't insist on it from a tenant. So if they offer it up, you can accept it after the tenancy started. So for month 2, 3, 4, 5, 6 onwards, you can take a rent in advance payment. But obviously it's a rolling month by month tenancy. So potentially you have to pay that money back if they decide to leave at an earlier stage. With regard to the actual rent amounts you can charge, that's going to be determined by what they call the market rent. Who sets the market rent? It's generally people like ourselves, agencies, when we're remarketing properties. But what it does mean is you cannot advertise a property, for argument's sake, at £800 a month, get 20 applications, and then decide to say, well, if you offer me another £50, you can have it, and to put a preference over one tenant over the other, and that will be banned. And you will be looking at rent repayment orders back to a tenant if you're found out to be doing that, so don't do it.
I think one concern is obviously a lot of our investors, a lot of our landlords have bought in developments where there may be 20 other flats similar to theirs or more, and it may be a case of one flat rents for say £800 a month, but maybe Mr. Bloggs' flat is on the higher floor and is bigger in size. I'm assuming they can charge more rent than the one that's just been let on the floor below, for example.
It's a bit of a grey area, because it's who does set the market rent, and as it stands currently, the market rent is what people are willing to pay for a property. What you have to be careful of is called the rent bidding, where you're trying to pit people off against each other. You can't take more than your advertised rent.
I think that's the key, isn't it? It's you can't take more than what you've advertised it for online.
Yeah. So I think the reality is people will just hedge their bets. So if you think you would normally get £1,000 a month, and there's a lot of interest in that type of property in that area, and demand is high and supply is low, you'll just put it on at a higher rent. What you have to be very careful of by playing that game is, market rent is normally £1,000. You think you get lots of interest, so you think, well, put it on at £1,200 and just see what happens. You put it on at £1,200. Somebody pays you the £1,200, and then they see all these other properties popping up at a lower value. The tenant can then report you to the first tier tribunal, where they can contest the rent. And if that happens, and if it's upheld by the tribunal, you will have to pay that rent back to the tenant plus a penalty. So just be very, very careful about what you set your rents at. Be reasonable Obviously, you get the most you can for it. It's a business transaction in the day between tenant and landlord. You're providing a service, they're paying for it, but there are, with this new legislation in place, lots more things you have to be wary of about getting it right.
And I think that's where we can come into play as well, is, we know the market, we can test the waters, and we can maximise the rent without having to, be chasing our tail and putting them low and then trying to increase them. We all kind of have a very good idea when we're coming to let it exactly what that market rent is going to be.
Yeah, absolutely. I mean, this is another thing we're going to be doing for our clients is we're building in an annual rent review as standard. So rather than contacting our clients to ask what would you like your rent to look at on a renewal, because obviously there's no more renewals because there's no more fixed term tenancies. So every year we will just be assessing each property's rental value and increasing it in line with market rents, because the market rents generally increase around 5% every year. So we'll make sure that the investment is getting the best return it can year on year without fail.
Cool. I think we've got a few minutes left. So
we got right. Okay, I'll quickly whiz through these then. If just the last points on here. So the 1st of June, all tenants must have received the government information sheet. So you do get a period of 2-3 months to get that out there. The 1st of August is when all the possession claims with Section 8, Section 21 of the old notices have been served. And then throughout 2027, there will be the implementation of the landlord PRS database where landlords must register. You will have to pay a fee, unfortunately. I was at the Property Mark conference a couple of weeks ago where the chief ombudsman for the property ombudsman was there, and she was saying that it's expected to be around £90 per landlord, but that's still unclarified at the moment or unconfirmed. Where you have to put on their type of property, size, layout, all your safety certificates have to be uploaded as well. And that's the whole of phase 1. Phase 2 doesn't start until 2028 when you have the implementation of the PRS Landlord Ombudsman Scheme. It was previously referred to as the Redress Scheme, but they've rebranded it the Landlord Ombudsman. And then phase 3 is the kind of third stage of the whole act. That's not expected till 2030. So again, we're kind of 4 years away from that. That's when they'll be bringing the decent home standard for the private rented sector. So all property will have to hit a certain minimum standard. And also the introduction of AWAB's law, which again is a bit of a hot topic because it deals with damp in a property and what constitutes damp and how a landlord deals with reported damp from the tenants. So I could probably do a whole of the webinar just on damp. But again, if you're managed by a good agency, you don't have to worry about it. We'll take care of it for you. If you're self-managing, just be wary of all those points when they come up.
I think there was a question about damp as well. So I think any points we haven't covered, feel free to reach out to Ross after this with more niche questions, and he'll be happy to answer. I think we'll all be singing from the same hymn sheet to say the main things we're going to care about are gaining possession to the property and how much rent we can charge, which I think we've covered. And I think you've covered kind of the transition from existing tenancies into the new tenancies. Maybe we can touch a bit on pets. There's a couple of people asking about pets in the properties. So what rights, will tenants have to request pets, and when can landlords refuse it ultimately?
Okay, I'll just quickly touch on this. So a landlord cannot refuse a tenant's right to have a pet once they're your tenant. So if a tenant applies for a property with a pet, you don't have to accept them. But once they are your tenants, they can request it and you can't unreasonably say no. The reasons why you could say no are generally if there's a higher power stipulating sort of a head lease or a mortgage stipulation, for argument's sake, which say no pets in a property. But I can't see it changing much from how it is now. So if you've got a leasehold property, it's very unlikely that things will change. A third story apartment where a tenant wants to have 3 dogs, you're perfectly within your right to say no. It's very reasonable to do so. But you just need to make sure you navigate that conversation and reply to the tenant within the correct timeframes.
Thanks, Ross. I think that's really useful. It's very clear Ross really knows his stuff when it comes to talking about this. So, you're in very safe hands. He certainly knows a lot more than I do. Hopefully that was really useful. And as I said, we're going to be doing a lot more of these webinars. We've got some really, really exciting property launches coming up in 2026, which we're excited to share with you all. So, stay tuned for more information on those webinars, and just generally more information coming from us as a whole company.